Hi, everybody. I'm Rich Ward. With me is John Massaro, both class of '89. We are in Williamstown. It is, I think, up to 14 degrees outside right now. So it's up much better than it was this morning when it was 0. We are here doing a winter study course focused on law, cybersecurity, and society. We kind of bounced around a number of different ideas when we were putting together the course. So rather than focusing on only technology, can we talk more about the cycle of change where something happens, technology changes, society gets burned, law changes, and how well that turns out. Because as we all know, it's very difficult to write law to be catch all the stray cases. Can we give enough of an overview in this area with two fairly specialized fields, law from John and cybersecurity from me, to be meaningful so that the kids can get something out of it, and also without getting into too much depth that no one can finish a project or anything like that. We have looked at some other ways of doing this, doing an actual like hacking thing, or there's an interesting effort at Yale to do this as part of the law school. And we also said, this is just a winter study. Let's see if we can get this all together and do it in just 7 days. And so far, seems going well. We have done 5 classes as of now, and our students, or some of them, actually asked us to lunch today. So we figure that that's a big win. So all's going well there. All right. So how do we get here? We are living in a highly connected world right now. We've had some fun with some references, but War Games, for those of you in our class adjacent years, was a movie in 1983 where Matthew Broderick accidentally breaks into the NORAD computers and threatens global thermonuclear war. The reason this came up, however, is this was a period of time when lots of people were connecting slowly, and lots in this context means like 10s, 20s, and 50s, small number, absolute, but more than ever before, were connecting over dial-up services. This actually led to the president of, or chief legal officer of GTE, a telecom company back in the day, testifying to Congress that War Games was in fact an accurate representation of what could be happening if they don't take some action now to talk about computer access. By the end of '88, a mere 5 years later, the Morris worm, which we'll talk about a little bit, paralyzed the nascent internet and caused lots of interesting people to get very upset about stuff. At that point, in 1988, there were about 100,000 nodes, maybe, attached to the internet. 2020, there are about 20 billion nodes pursuing the internet. So just highly connected, unbelievable level of direct discourse that no one really anticipated. Now everything is local. Everything is right there. Your neighborhood is kind of an archaic concept. And the physical world, you're like, oh, of course, I've got my neighborhood grocery store and I know where I walk my dog and I go around, and that's kind of like the human nature that, oh, we understand small sets of things, how to assess risk, where we are, where you kind of like keep an eye over your shoulder if you're walking some different part. In the internet, none of that applies anymore because everything is connected to everything else. And so your sense of local actually needs to include people in St. Petersburg and Shanghai and Tokyo and New Zealand. It's everywhere. All right, so everything is super connected. What does that mean? Well, this is a complicated world. In traditional physical architecture, people have been building bridges for thousands of years. For those of you who took art history 102 back in the day, I hope it's still doing it now. You're talking about some of the bridges in the Roman Empire and other areas, and how they learned how the arch worked and all that good stuff. Building software has really only been around for about 70 years, and it is a young, somewhat precocious technology. Now, to be sure, we've been building bridges for thousands of years, and many of those bridges fell down a lot. So now we have, over the years, come up with engineering standards. We have new layers of applied engineering, applied physics to understand the forces, and you go talk to your civil engineer before you do something and build your house, and all these kind of things that have evolved over time to make sure that you are in a relatively safe place and that the wall will come down and smoosh you. But software is still young, and the tools change and the environment change almost as quickly as the knowledge and the stuff that you've learned in the last cycle. So very quick turnover, and it's a complicated thing. So the software also has boomed into everyone's life. It has infiltrated its way into all areas of life in ways that we could not have imagined back in the 80s. So back in the 80s, maybe you remember, we're sitting here, there's a Jessup Hall, had a whole bunch of computers you could go to with your floppy disk, and you could type into WordPerfect or something like that. Now, everyone has a far more complicated phone in their pocket. You're connected to the world's knowledge. And by the way, if you are trying to make any kind of purchase, you're probably using at least a credit card, if not your actual payment device on the phone. It's everywhere. Email, phone, messaging, everything is there. Software and hardware together have grown faster and more complicated than virtually anything else in history. So far, it's been a wonderfully exponential growth in the 30 odd years since I left here. We've seen a complete regeneration or a complete shift in the software or the technology world. It went from very expensive mainframes to back to PCs and portable devices, and now we're back to the cloud and smart client terminals again, all sorts of things. But the number and the complexity of things continues to grow, and they are permeating everything. Really hard. Software is complicated. Software is very complicated because cause and effect are not always immediately visible. So very easy to see some things happen in the physical world. In the software world, basically there's some ideas, a memory, the bits, the files are changing in ways that are not maybe planned, and they interact in truly unforeseen ways. These are complicated systems doing a lot at the same time. And in the physical world, where you might say, oh, a building is a complicated system, but generally speaking, the elevator doesn't also run the plumbing. There's good separation of roles. In complicated software systems, there's a lot more overlap because a lot of things have to be shared. So one of my favorite illustrations for this is why it's hard to diagnose when there are physical artifacts. So in the real world, when something happens, let's start with it. This is an image of a Nissan 6-cylinder engine. As everybody knows, everything is better with a car analogy. So this is your typical engine. You can look at it, and even those of us who are not car people, I'm not a car person, can look at this and say, that looks like an engine. Looks fairly, reasonably complicated. There's a bunch of moving parts, but it looks like it's doing what it's supposed to be doing. This, I am assured, is the same class of engine from Nissan with a blown cylinder. So a blown cylinder is apparently when the cylinder that the piston is going up and down in fails and something goes horribly wrong. You can look at this and say, whoa, something is wrong here. I'm not a car guy, but I'm pretty sure that thing that's sitting out under the orange bit is supposed to be on the inside, and I need to go find a mechanic. This would have been helpful when I was younger as well. In the software world, we don't get this kind of luxury. What we have is the software is running in memory. It's not permanent. And then if you make an error in your arithmetic, if you've counted things incorrectly, if you didn't expect something to come in, if you're thinking that you're going to get maybe 5 characters sent to you and you got 50 and you didn't plan for that or account for that, then wow, things go horribly, horribly wrong. But then it's gone. So it's very difficult to figure out what happened. And so over years, we've learned how to add logging and all sorts of diagnostic tools to help figure out what's going on. But in the main line, this stuff is whipping through as fast as possible. And because we want all this computer stuff to run as fast as they can, sometimes error checking doesn't happen when you want it to. So it's a complicated world out there. All right, so let's put it together. We're running fast today. In 1988, when we were actually here, when I was here, a first widespread worm happened. So Unix systems all over the world, like there are about 60,000 of these things out of the 100,000 devices, started misbehaving. Things weren't working correctly. Things slowed down. People were locked out of their email. They were locked out of their systems. They couldn't get work done. No one knew what was going on. Basically, it was a very confusing moment. This was November 2nd. It was here. I was actually helping to run the computer, or at least the CS department's computers at the time. I was like, whoa, what's going on? Something's wrong. A graduate, a postgrad named Robert Morris leveraged vulnerabilities in the Unix system, as well as weak passwords for other systems to get a worm running around the internet. This worm was really, it was very clever at the time. It was counting on a very simple problem, a buffer overflow, which went into some detail in the class. We'll skip over for here, but it exploited the fact that someone didn't know how to count on a system that would come that are a system service that let you find out who was logged onto the system elsewhere. And he also leveraged that people, even though they had passwords, they didn't have very strong passwords. People often did simple things like their name or their name backwards or the name of their project and things like that. So he counted on either finding a system that had the software flaw where he could just directly inject his code to some other computer down the network, or he would use another way of connecting the machine and then try a whole bunch of passwords on account names and passwords and see if he can get in. This was not as efficient, but it was surprisingly effective. At the time, he was doing this and thinking, hey, I'm going to do this just to see if this works. I'm going to be, and somewhere in there, it got loose. Now, he also decided to make it look like it was coming out of MIT when he was actually elsewhere. So one would say that he was trying to not be caught doing this. But here's the situation. He put together this worm. This worm is replicating around the internet. He had a governor in there to try and make it only spread on 1 out of every 7 things, but he kind of got the logic wrong. So it's really going on, replicating a lot faster than that. Things went south. A lot of people were unhappy. Internet was a interestingly connected network at the time, small, but also connected to some important people. And this was the first opportunity to prosecute someone under the Computer Fraud and Abuse Act, which was foreshadowed by the War Games movie of all things. So John's going to talk a little bit more about that side of things as we go. This was a kind of a shift. And here's why. This is where it was kind of the last time, there's a few more, but this is really the last time where the attacks were largely benign. And by benign, I don't mean that this was blameless or guilt-free, but more that he was just trying to see if it would work and if he could replicate, get things going around. There was a series of attacks against various properties and systems in the 90s and early aughts, saying what we call bragging rights. They wanted to either deface someone's website or get bragging rights to showcase that they're smarter than Google or Microsoft or Apple or whoever. And finally, there was a lot of them who were like, I'm going to be a security researcher, and the way that I can prove to my future customer base that I am smart at this is to crack some system and get credit for it, and then take it, say, haha, if you don't want this to happen to you, you're going to hire me. There's a shift at that point from that kind of bragging. By the mid 2000s, people weren't bragging. They were using this for other purposes. Crime, common case, Uh, I think people have probably heard of botnets, perhaps, where thousands of machines are controlled by someone else to further someone else's goals. Like, oh, I'm going to enslave 1,000 or 100,000 PCs that people have left unprotected, and I'm going to use all those guys to attack a a website like Google all at once. And also more than just crime. There's you know, national security issues. There was attacks between nation states. This was a kind of the end of the innocent era and into like, hey, there's a lot of money here. The bugs that we had where someone couldn't count right or copied things around and didn't know what they were doing, those bugs became vulnerabilities. So the things that used to all get lumped together as, sometimes things break. So like, oh, hey, these things could actually cause real problems. The vulnerability where someone could later write an exploit that would take advantage of that vulnerability and then put people or data at risk. And people and data really are at risk in this. And I think ransomware is a well-known issue that's going on right now where you're minding your own business, something's gone wrong, someone takes over your system, encrypts all your data, and then says, oh, transfer me $1,000 in Bitcoin if you want your data back. That's easy case. In uh, 2008, I think, the WannaCry virus was a similar activity where the a vulnerability that had been patched and the patch was available but has not been applied was exploited by some people who were using it for ransomware. That particular attack then incidentally hit the National Institutes of Health in Great Britain because they had they are not an IT pro shop, right? They're focused on actually managing people's healthcare. Their machines weren't patched. Many of their devices were locked down by this attack, and then they had to start rescheduling surgeries, and they had to move people around, and people didn't get their prescriptions and stuff like that. So suddenly, people are really at risk. It's no longer, you can't do your job anymore, or Google didn't get to do this, or Amazon missed a shipment. It's, hey, people are going to become sick or die. This means that the vulnerabilities become enormously valuable. So in 19 in the 90s, vulnerabilities were again for bragging rights. In the 2000s and certainly by the 2010s and later, we have vulnerability markets, the so-called dark web, where people are like, hey, I have an exploit that I know a vulnerability and I have an exploit for example, your iPhone that no one else knows about. And suddenly that became hugely valuable because if I can get onto a system, I can, especially a system that you trust, like your phone or your whatever device that you trust, and I can break it. Wow, that's super valuable. So at this point, an unknown vulnerability on an iPhone with zero click, as we'd say. So just for example, sending someone a message is worth about $1.5 million on the dark web markets that exchange these things. It's a whole new economy. Now, these tech changes introduce new needs for the law. So as all these things are going up, the world is changing. How do you express the value that you have on this in this device? The value of the device is not the value of what you paid for it at the store. It's no longer a simple matter of property case or a property situation because you've invested a ton of other things into this device. So you've got all your photos, you've got all this other stuff, important documents, plans, business plans. Espionage is a problem. Um, the law needed to adapt. And this is a situation where the rapidly shifting technology created some tension on older assumptions in law that, things like, oh, you've got a lock on it, or things that made it so that you've got enough protection that you can assume something else. Well, maybe you need something more than that. My personal favorite, a lot of things that are prohibitively expensive in the old days. So when we were here, no one went to a copier and copied a textbook. That was ridiculous. It would take forever. It was 10 cents a page. You're killing yourself. What are you doing? But now, if one person scans that textbook, and piracy is granted, it's actually economically viable. So things that were not feasible and the law kind of ignored in the past are suddenly present because technology has made it a lot cheaper or easier. This can factor into surveillance, this can factor into copying and show up in lots of different ways. So that was kind of the side from the technology front. And then we kind of throw it over to the legal side. And so each of our classes is kind of this way, where I'll blather on for a while about the technology change. And then John comes in and says, well, here's how the rational thing works. All right, I'm going to try and stop sharing here. We'll see how this goes. All right, you're up, man.
All right, don't forget about muting. And I hope everyone can see the slideshow continuing. Just by way of introduction, I'm John Massaro, class of 1989. In the promotional materials that went out, there were pictures of me and Rich side by side. It's probably hard to tell the difference. I'm the one with the headphones, just so you know. I also have a spouse, Patty Donnelly, who is also class of 1989. We met during winter study in 1987. So there are some fond memories here as I stare out the window at my freshman room in Sage E. And Rich didn't mention he and I have, together with our spouses and our dogs, rented a house on Hoxie Street. We're getting the full experience. It's a joy. Anyone who might consider doing this should look into it or talk to us about it. It's been fun. After graduating from Williams, I went to law school. I worked for a judge for a year, and then I went and worked for the law firm that I still work for, Arnold and Porter in Washington, D.C. I've also taught some law classes over the years. For the last 16 years, I've taught at GMU Law School, just a local law school near where I live. One thing we debated when we were thinking about this presentation was, to what extent are we trying to give you guys a sense of what it is we're doing here in this class up at Williams, by giving you a sense of the global scope of the class and where it's headed? To what extent do we want to actually share with you a little taste of the actual experience? In other words, pedagogy versus substance. We mixed them up a little bit, give you a little bit of both. My goals for the class from the legal standpoint were twofold, and I told the class this is my goals. The first was to use cybersecurity issues and events as a prism through which to get a feel for various subject areas in the law, the different subject areas of the first year of law school, different elements of different causes of action, different legal things experienced through the prism of cybersecurity law. So give students a taste for some substantive areas of law. And second, to do some real close reading of judicial opinions. We're reading some actual judicial opinions that I've edited, and maybe some discussion of them, and really getting a sense in a hands-on way, hopefully, of how it is lawyers think and argue and the sorts of rhetorical devices that lawyers use. Of course, let me just make sure that is the next slide. Yes, it is. The law is, of course, only one way to regulate behavior. And on the screen here are a number of other ways that we discussed. You know, as we sit in the classroom in the Commonwealth of Massachusetts, the Commonwealth is regulating our behavior with laws, but societal mores, local market factors, voluntary associations, even the architecture of the classroom suggests something about the way the class is going to be conducted, how the dialogue is going to occur, and how people are going to enter and leave the room. All of these are among the factors that can regulate behavior, and the law is just one of them. It certainly draws upon and relies upon some of these other factors, but please don't place the whole burden on the law. But there are a variety of different legal approaches to problems. And we start, there are 8 different meetings, 8 different days that our class meets. The first day was an introductory day, and the last day that we'll hear from the students themselves with their presentations. But on day 2, we talked about the common law, the law dating all the way back to ancient England, that judges draw upon, contract, tort, and property law. And we saw through some examples, which I'll share with you momentarily, ways in which the common law was helpful, but also ways in which the common law fell short in dealing with some of these cybersecurity issues that are so modern and different. And so with the common law falling short on day 2, we said, well, maybe statutory criminal law can help whack down the mole, like in this giant game of whack-a-mole that we're playing, can help whack down some of these problems that have cropped up when the common law was trying to be used to solve the problems. And we found, as we'll discuss in a moment, that the criminal law had its own problems and difficulties, as well as some of the same problems and difficulties that the common law had. Well, if those two things aren't perfect, maybe we can marry them together in some kind of Garanimal-like way and craft into the criminal law a private cause of action. So add to the criminal statute the ability of a private plaintiff, an individual, to bring suit against the person who has done something in violation of the statute and recover damages. Well, there are limitations and weaknesses to that approach as well. And those limitations and weaknesses come from the institutional role of courts and what courts are willing to do and not willing to do under the Constitution of the United States, as well as the rules that we have set up to govern the way courts operate, including specifically Rule 23 and class actions, but other rules as well. On day 5, which was today, we realized the government realizes, hold on, in enforcing this criminal law, I actually am using some of the very same tactics in investigating crimes and prosecuting crimes that are illegal under the very law that I'm trying to enforce. So I better exempt myself from that law. And we worked through, even though there is a government exemption from some of these criminal laws, we worked through the ways in which nonetheless the government is constrained by the Constitution of the United States, the Fourth Amendment, Fifth Amendment, First Amendment, in its prosecution of crimes in the cybersecurity realm. Thursday, we'll be dealing with that same topic, but in the more sexy context of national security. On the one hand, the government, the Constitution gives the government great powers in the national security realm. On the other hand, the Constitution also constrains the government in some ways, and we'll be talking about that on day 6. And then on day 7, sort of an extra credit topic of inter-sovereign relations, the international dimensions of some of these problems. If you've been to law school or you know someone who has, days 2 through 6 may look familiar to you, because what they are is the first year of law school: property, tort, contract, criminal law, criminal procedure, civil procedure, and constitutional law. In other words, we're exploring cybersecurity and getting a little taste of each of these areas of the first year of law school while we do it. So without further ado, let's do a little bit of what we did in the class in this respect. We started, the first case we read was called eBay v. Bidder's Edge. I think everyone knows what eBay is. Bidder's Edge was a price aggregator. They would go onto the website of various people like eBay and say, oh, eBay is selling a razor for $1. And look, Walmart over here is selling a razor for 95 cents. On our site, on the Bidder's Edge site, we will aggregate those prices. We'll show you that you can get it in one place for 95 cents, in another place for $1. eBay didn't like that and brought a lawsuit against Bidder's Edge to stop Bidder's Edge from doing that. And we see the judge grappling with how to deal with this problem, this cyber problem, if you will, utilizing these ancient tools of the common law. So the judge starts at the bottom of the list that I have on the screen. Is this a tort? Is there some kind of intentional or grossly negligent conduct on the part of Bidder's Edge that is violative of the duties that we all owe to one another, and in particular the duties that Bidder's Edge owes to eBay? Is Bidder's Edge using this website in a way that's inconsistent with the way that eBay intends it to use the website? And the judge concludes that while there is some truth to this analogy or this approach, this isn't the approach that would lead to eBay prevailing in the case. The judge then moves to the next topic of the common law, contract law. There were some terms of use associated with logging on to eBay's site and visiting eBay's site. To what extent does the entering into eBay's site constitute a contract between the person who's visiting the site and the person who is hosting the site. And the judge analyzes that as well and concludes that the elements of contract, at least on the facts of that case, were not present. There was not a real offer acceptance, conscious acceptance, meeting of the minds between the two parties such that there's a contractual remedy here. And then the judge proceeds finally to property law and the trespass analogy. Is bidder's edge stepping into a zone on the eBay site in a way that's inconsistent with eBay's property rights? And the judge says under California law, the standard for that would be, is there a tangible interference with eBay's property or the chattels on the property? And once again, just like lawyers do, each one of those words becomes the subject of further discussion. Is the electrical impulses that bidder's edge is sending to the site as it browses about the site sufficiently tangible to constitute tangible interference? The judge concludes yes. Is the visiting of the site by bidder's edge somehow interfering with eBay's ability to use the site? The judge concludes no, but it's intermeddling, and that's good enough. So in the end, eBay does win this case. It wins it after a long common law analysis by the judge. And we see some features of the common law at work in the judge's discussion of this case. And some of those features are problematic. The common law is old, and these problems are new problems. So it doesn't really fit like a glove on a hand. The common law is cautious and incremental, and these problems are rapidly evolving problems involving new technologies that don't wait for the leisurely pace of the law. The judge and the participants in the proceedings are relatively uninformed. They're not experts in this area and in the technology that's involved. The common law is wordy and unclear in many ways. Now, if you recognize this list, it's the law and it's lawyers. It's those of us that practice law have these features and many other features that bring disadvantages and make us imperfect in dealing with problems in this cyber area. So if there's a problem with the common law, maybe we can whack that mole using a statute. Maybe we can actually write down the exact words that we want to figure out what conduct it is we're forbidding and what conduct it is we're allowing. And that will solve some of the problems that we're facing here. So we start in the class drafting a statute, and the class does a pretty good job of drafting a statute that looks like the very first criminal statute that the United States passed, the Computer Fraud and Abuse Act. And this is the language of the Computer Fraud and Abuse Act that was applicable to the Morris case that Rich alluded to earlier. You can read through it. The operative phrase here is without authorization, right? Did Mr. Morris intentionally access a computer without authorization? Well, Rich described to you what it is Mr. Morris did. Here's a little bit more specificity in some areas, but he sent an email with a worm in it, and that worm took advantage of a bug in the software of the recipient of the email and then spread throughout people's systems. He sent an email. Well, Mr. Morris says, I was certainly authorized to access the computer that I accessed, the one that I sent the email from, and I was authorized to use that computer to send emails. So what's the problem here? There's no violation of the statute. The Second Circuit disagrees. And it disagrees because Mr. Morris's conduct violates the intended function test. Well, wait a minute. Hold on. Let's go back to that statute. Where does the intended function test come from in the language of this statute? As it turns out, in interpreting the phrase without authorization, the court has to have some sense for what is meant by without authorization. And the court looks to the common law to get a sense for what that means. And in the common law, the court finds that without authorization means inconsistent, acting in a way inconsistent with the intended function of what the program was meant to do. Now, there's a lot of ambiguities in this test and a lot of problems that the test introduces. I won't dwell on them here. But Congress goes back to the drawing board. Mr. Morris is, by the way, convicted, but nonetheless, Congress doesn't want the messiness of having to invent words on the spot the way the judge had to in the Morris case. And the statute is amended to make clear that it's a crime not only to access the computer without authorization, but also if instead what all you do is exceed your authorized access, then that too is a crime. And for good measure, we're going to define the phrase exceed authorized access. So there'll be no need to consult the common law any further about this. And here's the definition of exceeds authorized access. As it turns out, there was a United States Supreme Court case 3 years ago about this very definition and its applicability to the facts of the case. And the whole case hinged on one word in the definition. What word might you guess is the word that was the subject of the United States Supreme Court case? Well, look at the last line of the definition. It's the word so. The parties are disputing the meaning of the word so. Here's the facts of the case. It was Van Buren, 2021. Mr. Van Buren, Nathan Van Buren, was a police officer. He had a buddy, Andrew Albo, or at least he thought he was his buddy. Mr. Albo approached Van Buren and said, I'd like you to check out this woman that I met last night. Run her license plate for me, please, because I'm concerned she might be working with the FBI. Apparently, the reference to working with the FBI was not a sufficient red flag to Mr. Van Buren to know that Mr. Albo was, in fact, working with the FBI. Mr. Van Buren ran the license plate search and received $5,000 from Mr. Albo in return for doing so. And then Mr. Van Buren was indicted for violating this statute that we just read. And what he argued was, well, now hold on. I didn't exceed authorized access. I was authorized to access this computer, and I was also authorized, in fact, to so obtain it. In other words, to obtain the information that I did obtain, I was authorized to obtain that information from the license plate database. I had access to the license plate database. I was given access by the department as part of my job, and I did access it, and therefore I was entitled so to obtain the information. The government says, no way, wait a minute. The word so doesn't mean using your computer. The word so means under all the attendant facts and circumstances in which you did it. And what that means is the word so is impregnated with the entirety of the police department's policies governing your use of this information, as well as with societal mores and common sense about what kinds of uses and not uses are governed here. So all of that is brought into the statute, says the government, through the use of the word so. Does this matter? Well, here's a chart saying why it might matter. This is what the Department of Defense placemat says about what the word so would mean if the government's interpretation was correct. These are all the policies, very helpful list of all the policies that the Department of Defense thinks govern your use of information if you interact with the Department of Defense about its information. So there's a lot at stake here. It's not just the police department policy in Mr. Van Buren's case, but potentially something as big and complicated and difficult to understand as all this. Where did things land? Well, Justice Barrett writes for the majority that she is siding with Mr. Van Buren, that the word so means simply by means of computer, and that the word so does not carry with it all the things that the government wants carried with it. And Justice Barrett gives us a test. She says that the test is whether the gates were up or the gates were down. Here, the gates were down. Mr. Van Buren was physically allowed to access, physically permitted to access the license plate database. The gate was down. And so it doesn't matter what purpose he accessed it for. As long as the gate was down, he's good. If the gate had been up and he had circumvented it or jumped over it, then that would be bad. That's Justice Barrett's interpretation of the statute. And in fact, Justice Barrett gives us a holding, the thing that is meant to guide us in the future in understanding with a little more precision how it is we're to conduct ourselves under this statute. hopefully the holding will give us a little more clarity about what we're supposed to do here on this gates up, gates down. There it is. So it covers those who obtain information from particular areas in the computer to which their computer access does not extend. That sounds like a circular sentence to me. Those who get things from places they can't get them from. It's not clear exactly what it is this means. Really, at the end of the day, the work in this sentence is being done by the word access. What do you mean by access? And Justice Barrett would have us think that she means, I think, that the gates are up or down, but that's just a metaphor. What do you really mean by the gates being up or down? Do you mean the terms of use? Do you mean societal mores? Do you mean some kind of physical gate of some kind inside the computer, some kind of physical technological barrier? It's not clear. Hold on, there's a footnote here. Oh, let me see if I can make that bigger. Oh, for present purposes, we need not address that thing, Massaro just said. We're going to leave that for another day. So that's the guidance that the United States Supreme Court has for us on this touchy issue. What we see in a moment is that the common law problems, maybe some of them continue to exist even once we draft statutes and even once we amend those statutes to make those statutes more clear. But to that in a moment. The other thing is that the criminal law actually brings with it a whole new set of problems. First of all, statutory criminal law brings with it problems of statutory interpretation. How do we interpret statutes? Do we just read the words? Do we go beyond the words? If we are going to go beyond the words, where do we go to go beyond the words? That's part of the fight that was happening in Van Buren, and there are principles and canons of statutory interpretation. Legislative history can or cannot be used in statutory interpretation depending upon what political party you might belong to. There are different fights one has about the principles of statutory interpretation. There are also some other doctrines that the Constitution imposes upon us, not the actual words of the Constitution, but the way the Constitution has been interpreted imposes upon courts and society additional limitations on the use of the criminal law to regulate behavior. A statute, if it's too vague, can be held to be void for vagueness because it doesn't provide adequate notice to the person that their conduct is violating the statute. We shouldn't put someone in jail for doing something that we didn't make clear to them in advance they shouldn't do. The rule of lenity says, in essence, the tie goes to the runner when there's a lack of certainty about a statutory issue in the criminal law context. The tie goes to the defendant. Of course, we're all familiar with the heightened burden of proof associated with criminal actions and the need to prove a guilty state of mind and the need for unanimity. So if the common law had problems associated with it in controlling our behavior, it turns out statutory criminal law has a whole new set of problems. And now that I think about it, maybe it also has the same old set of problems too. For example, was Mr. Van Buren's conduct or was Mr. Morris's conduct consistent with the intended use? Remember, we had the intended use test that was invented in the Morris case to interpret the terms without authorization. We're grappling in these statutes with the question of whether something is consistent with intended use. Didn't we just grapple with that in the eBay case under the common law framework? Isn't that the exact same issue still somehow showing up, even though we were trying to use the statutes to solve that ambiguity? We also grappled with in Morris and Van Buren whether the conduct is consistent with agreed upon limits. In other words, the contractual issue of whether there's some kind of agreement between the parties about what sorts of conduct is allowed and what sort of conduct is not allowed. Again, back to the common law. That was there in the eBay case, and we're talking about contract law. The first topic, consistent with intended use, is about intent and tort law. The second topic, consistent with agreed limits, is about agreement and consent and contract law. And the third topic, the law of the nation, at least as to this statute, whether something is allowed because a gate is up or a gate is down. The metaphors comes right out of property law. And of course, the concepts are coming out of property law too. The idea that there's some area that is protected and some other area that is on limits versus off limits. The gate separates, just as it does in physical property law. There is some metaphor being used about a separation and trespass. So once again, we're confronting really the same issues we confronted in the eBay case with the common law. So are these problems that are only with the common law? It turns out not. These are problems with the law more generally. And as we walk through the rest of the semester, we'll see some of these same problems cropping up again and again in different contexts. I think at this point, we're ready for some questions.
So, one question has been entered so far, and I'd encourage everyone to do it again. If you have a question, please type it in or whatever. So one question, which is not actually from Julia, I don't know who it's from. But the question is basically, what are we talking about for password guidance, and what's going on with passwords? So there are two branches to this question. One is when you are protecting something like your phone or your data on the phone, your pictures, all that good stuff. There's what password there, and then there's also what password to use when you're connected to an account online. So problem with passwords is they involve humans, and humans are terrible at generating sufficiently random information. So even if you have an 8 character, you have a 16 character, you have a 32 character password, most people don't pick sufficiently random things. And even when they do find relatively random things, you're choosing from a very small alphabet. There are 26 letters, they have lowercase, maybe add in some digits, things like that. You really are talking about a small number of actual interesting bits of entropy. It's you may think you're doing a job, but you're not. So the better solution is, so on the phone, for example, you have a PIN. You're like, wow, it's a 4-character or a 6-digit PIN. What, isn't that weaker? But the answer is no, because you are authenticating to something in the phone, and the phone will not unlock a really good key until you've authenticated. And if you guess the PIN wrong 5 times in a row, well, or 10 or whatever your setting is, it's going to wipe your data, and you're safe. On the other side, when you're authenticating to your online bank or something like that, you do want to have some kind of authentication process where it's like, hey, I can't talk to the phone. I don't trust the whole stack of trust for my bank connection. So I want to do a 2-factor thing. The best solution we have is I'm going to authenticate. I'm going to say, here, my account name is RBW, and here is my password. Then it says, okay, bring up your authenticator app, or I'm going to use some other second factor of authentication to do the authentication and prove that you are who you say you are, and then your bank or whatever is satisfied that you are not being your weak password has not led to a worse set of situation. So it's a little more practical than otherwise. These questions. But do we have any other things? I can't believe that we totally nailed it here. Julia is full of questions today. John?
Yeah, I do see a question here. It's asked, will the law be able to keep up with the speed of technological progress? Should we rely more on the other ways to regulate behavior? In other words, maybe you can mute. We're in the same room, by the way.
We are in the same.
Yeah, it's a good question, right? Like John, a classic question in law school, like, hey, law professor, you just spent 40 minutes telling us the problems, and that's really great, but what's the solution? And then the answer is, I don't really have that for you. At least in law school, that was my experience. I do think there's a great debate, and we talk about it briefly in class, about whether this issue that I've alluded to is anything special or new, or is just the same old issue we've confronted over and over again. And it arises in the context of an article written by Judge Easterbrook about horse law. Judge Easterbrook says, hey, we don't have any books called horse law, and we don't teach courses called horse law. Even though, there are many cases involving horses, we don't develop a whole body of law relating only to horses or when a horse is involved in a situation. And that's because the old tools of the common law and the old tools that lawyers have developed for thousands of years, dating back to Moses, work just fine. The facts change on the ground, but the law that has existed for all time is good enough, in fact, is great enough to deal with those facts. And that's why we don't have horse law. We have property disputes that involve horses, contract disputes that involve horses, torts that involve horses. We organize it around those topic areas, not around horses. That says Judge Easterbrook. And of course, the rejoinder to that is no, there is something different about the cyberspace. And that's a little bit what, the example I just illustrated in my talk just now was meant to make the case for, that the traditional legal concepts are not, at least right now, fitting well with cybersecurity issues for a variety of reasons, dealing not only with the subject areas of the law, but also dealing with the people and the institutions of the law. So I do think, I think it's going to turn out okay. But I do think some things will have to change. We see in areas that are particularly important to the government, national security, for example, the country creating specialized courts and specialized legal processes to deal with cybersecurity issues that the government cares a lot about, and we may see some of that for us ordinary citizens as well. But I do think there will have to be some changes, but I think it's going to turn out okay in the end. I see there are some additional questions.
Yeah, we have new questions. I think you want to lead with the first one. What's your favorite part?
I think actually the students are. I loved the students when we were here, and my best friends are still people that I met here at Williams. But I think these people are super nice. I like them even more, to be honest with you. They seem like a great generation of people who really cares about one another, really is willing to listen to one another, engage with one another. They're all physically fit. They're all out there skiing and jumping around, but they're also willing to engage mentally as well. They also were kind enough to tell us, when the parties at Hoxie Street are and what houses they'll be in, so we can prepare for that ahead of time. So I've really enjoyed the students.
I think we can echo that. The students have been very engaged. This is a short period. It's not like we get a whole semester to kind of build rapport, and they've been really outgoing. I've been joking to people that we structured the course so this was not is offered under the CS department because they're too nice to say no to me, but we structured it so it would not require a CS background. And what we end up with is half the people are computer science majors and half are not, and the ones that are not are all over exactly what we would like from a school like this. We have, someone in math, we have someone in art, we have someone in Romance languages, we have chemistry. It's just all over, and they have concentrations, different areas too. It's been just, kind of fascinating having them share their perspectives. And the funny part is when I'm doing my spiel during this, because I usually do the first half of the class, the CS folks are kind of like, okay, go. And then when John's doing his, everyone else is like, oh yeah, they're asking. And John turns out to be much better at getting them to asking the open-ended questions. I get a little too factual, so they get to kind of, they're like, oh, okay. All right. In the context of increasing reliance on AI and machine learning, how can we balance the use of such technologies for protecting society while ensuring they don't ever infringe on privacy or civil? Okay, so I'll lead off. You should probably jump in on this too. Again, of course, fortunately or unfortunately, this is only a winter study course, and 3 of our classes were like, hey, we could have made a whole semester out of this topic area, and we've had to kind of like really kind of suppress it. And one of these was today. I was like, look, privacy is a huge issue, and we are kind of deliberately ignoring it because it is a huge issue, and we can't do it justice in a single 3-hour class. So specifically in this, our AI is a tool. AI has a lot of hype. AI is a very broad term applied to a number of different technologies. There's the generative stuff versus the pattern matching stuff versus lots of different areas. Um, so on that front, AI is not going to dramatically make anything better or worse specifically in the cyberspace. Dramatically. It is going to make things better or worse. Before I retired, I had some folks working on how we can use AI engines to do better penetration testing and automate it to make sure our products are better. How we could use AI, generative AI, to find and replace known bad things in old code when it's hard to get actual humans to look at it. If we can kind of make a broad sweep and fix up lots of issues, that would be a great win. So on one front, AI is going to be helping to move the needle, but that's not going to be a dramatic change. On the other side, the use of AI for fraud, it's going to grow. It takes a minute or two of audio of someone to be able to duplicate their voice now. So if there are already lots of fraud cases where someone will call and will sound just like your kid or your parent or something and saying, "Oh, I'm stuck in a jail weirdly in South America, and you need to get Bitcoin to get me out." Work out your own personal passphrase with your family so that you are not drawn into that, because you won't be able to tell the voice print anymore. So some things will be better, some things will be worse. But it's kind of more of a shift. How does that affect the legal framework?
Yeah, I mean, I have a number of hats that I wear at the law firm where I work. I'm a practicing lawyer by day, but I also have a number of internal roles, and one of those roles is on the chair of our risk committee. And I think there is a question about who is going to be responsible for making sure that whatever AI usage occurs in a responsible manner in compliance with the laws that we're all used to, because I think there is the capacity for much greater harm. And for our law firm, for example, I think most lawyers and the ABA has also put out some rules about this. Most lawyers agree. At the end of the day, a human has to own whatever it is that comes out. And in the law firm world, that's easy enough. If I use AI to put together a first draft of a brief, at least some human has to then ultimately sign that brief, and that person damn well better read that brief and understand it and ask the right questions, cross-examine the brief in essence to make sure it does what it needs to do and what it's claiming to do. And I think that same thing is going to have to happen in other industries, but we're going to have to figure out who ultimately is responsible for it. I also think there's a great, capacity for it to impact our personal relations. My daughter was contacted by her fiance who was home with his parents, and he said, you need to text me right now an excuse to get out of here. I can't take it anymore." And so she contacted AI and said, "Boyfriend needs to excuse for leaving parents. What are your suggestions?" And it came up with some great ones. And after further cross-examination, it got pretty good, I'll say. But my point is, even outside sort of the legal framework, I think our interrelations with one another are going to be impacted by this. And but that's not something the law can help with. I hope our souls help us with that.
All right. 4 o'clock. I don't see any other questions popping up. Julia, something just happened. Oh, hey, look, I got instructions. Thank you everyone for showing up. Very important. We have big numbers. I think, as we said, there are there are 2 other sessions this week. If you have time, that's great. If not, that's okay. It's more important you came to this one. And ultimately, our real goal is to, of course, help the students here, but also beat Darlingside because they're on Thursday. On that's all I got for you. John, anything?
That's it. Thanks for attending.
Thank you all.